Yes.
I'd like to make a mention of item 6 and 7. 6, 7. 6 and 7 are same, Your Lordship.
That you said the matter is under consideration before the Supreme Court.
Lordship, yes, that is what they say. Because against the judgment passed by the division bench, they have gone to Supreme Court. So the matter, I believe, is still pending. It will come after vacation, Your Lordship.
Then the counsel for the parties have submitted that the issue involved in this case is similar to the issues raised in another matter, which is pending determination by the Supreme Court.
No, Your Lordship. Against the judgment of the division bench, Your Lordship, they went to Supreme Court, the petitioner.
And what are these matters? How are these matters?
Lordship, because what happened, Your Lordship, their case is that the initial appointment has been set aside by the single bench of this honorable court, Your Lordship. So against that, a challenge has been made before the division bench. Division bench also upheld the decision of the learned single judge. So against that, Your Lordship also was part of the bench before the division bench. So against that, Your Lordship, a challenge has been preferred before the honorable Supreme Court.
So how are these cases involved?
Lordship, because if the Supreme Court upheld the judgment of the High Court, Lordship, then they have no case.
So that is why. So similar would be. The issues would be similar.
Lordship, yes.
The decision of which will have a bearing on the merits of this case. We pray that this matter may be kept in abeyance till after the vacation.
Lordship.
On premier, the same is allowed. This is matter after the vacation.
Apply, Lordship.
Lordship, I'll make a similar prayer for item number 4. Lordship, this matter is still pending before the division bench.
Division bench.
Lordship, for the state respondents 1 to 4, no objection. For respondent number 5, no objection.
Then the counsel has submitted that the issue involved in this matter is also under consideration by a division bench of this court, and as such, it is prayed that this matter may be adjourned till after the vacation. Pray aloud.
Lordship, similar prayer for item number 8. The connected matter is pending before the division bench. Item number 8, Your Lordship.
Same. Actually, same like. Who's?
I'm for the petitioner, Your Lordship. Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 9, Your Lordship. In this matter, I am supposed to file the affidavit, Your Lordship. I'll be filing in the course of the day, Your Lordship.
Why are you taking so long?
Your Lordship, because the pro forma respondents, he have to come and sign, Your Lordship, so we...
Unnecessarily is delayed.
No, Your Lordship, we'll be filing in the course of the day, Your Lordship. I am prepared, Your Lordship.
And we don't know, see, what substantial role you will play in the whole. Apparently, it is the dispute is basically between the petitioner and the respondent number 4.
I have bring some of the facts in that affidavit, Your Lordship. Let it come, Your Lordship, after 2 weeks. I'll be filing in the course of the day, Your Lordship, the affidavit.
On pre-made by Ms. Leonard Counsel, the respondent number
8, Your Lordship.
Number 8. Matter is adjourned. This is him after 1 week.
2 weeks, Your Lordship.
Now you see in the course of the day, now you see.
Yes, Your Lordship. But let this matter be taken up after 2 weeks, Your Lordship.
This is matter to after 2 weeks.
Much obliged, Lordship.
Yes, Lordship. I beg to make mention item 5, Lordship.
Nothing is left now.
So I'm praying that this matter may fix after vacation, Your Lordship.
This is that subsidy matter.
Subsidy matter.
You're not interested.
Your Lordship. We are interested, Your Lordship.
You withdraw
to
the
proceed,
matter.
Your Lordship.
On premier by the petitioner seeking accommodation. The same not be objected to by respondent. Matter is adjourned. This is after as agreed to by the parties. This is matter after vacation.
Obliged.
On daily list, item number 1.
May it please, Your Lordship. Lordship, I pray if this matter may be listed day after tomorrow, Your Lordship. Some more time may be given, Your Lordship. Day after tomorrow, Your Lordship.
What is your difficulty? Nothing is required here. Are you supposed to file the
Complaint, that charge sheet complaint.
Compilation of charge sheet, Your Lordship.
okay.
Day after tomorrow, Your Lordship.
Because you have not annexed the complete charge sheet.
I have enclosed the
Only the relevant
Yes,
portion.
yes.
We'll take up on after tomorrow's Wednesday. We have 2 division bench that day. Thursday. Ms. National Counsel for the respondent has submitted that the charge sheet, the complete set of the charge sheet could not be produced today and has sought for some time for the same to be produced. Accordingly, as prayed for, list this matter on Thursday, on 28th.
Obliged, Your Lordship.
Item number 2.
May I please, Your Lordship? Conducting counsel is engaging in another court. Let this matter may speak after the end of the book, Lordship.
What is this matter about?
Boxer matter, Lordship.
Notice to the private party has to.
Yes.
That is only the issue of notice, notice.
Yes.
Have you taken steps?
Not yet, Lordship.
motion,
Today, motion.
Oh, motion. Then you take steps.
Okay, Lordship.
Ms. National Counsel for the petitioner has submitted that at the outset the respondents 1 to 4 having been duly represented today, the notice may be allowed to be issued upon the respondent number 5. Accordingly, since the respondent number 1 to 4 respectively are represented by Mr. K. Khan, Leonard PP, along with Mr. S. N. Gupta and Mr. H. Abraham, any further notice is not required as far as the said respondents are concerned. Petitioner is directed to take steps for, as prayed for, petitioner is directed to take steps for issuance of notice on the respondent 5. Same returnable within 2 weeks.
I look as Lordship.
Item number 3.
Yes.
Lordship, in this case, the petitioner has preferred the SLP in the Supreme Court, Honorable Supreme Court. and we have got the diary number. So my humble prayer is that let this matter come up after vacation, and in the meantime the SLP, it will be listed for motion there, and we'll just see wait for the outcome.
Premier petitioner seeking accommodation. This is matter after petition.
Item number 10.
I notice the Lordship has started hearing the matter from last week. Lordship fixed today.
Your Lordship, the conducting counsel is on his legs in courtroom number 2. Would it be okay if I just inform him?
Yes. If he comes within 1 minute, we'll take it up.
But all after Lordship rise up division bench, Lordship may take up, subject to Lordship convenience.
We don't know how long division bench will take. You see, we still have time.
Yes.
If he's here, we'll take it up.
Yes.
Please. The appellant has been heard.
He has advanced his argument that he would continue. He will continue.
Not completed.
Not yet completed.
May it please, Lordship. Lordship, on the last occasion, I had opened the appeal a little bit. I'll just take, with Lordship's permission, I'll just take 1 minute just to refresh Lordship's memory. Lordship, the matter revolves around a lease deed that I had entered into in 1923, my lord. That lease deed was for 10.19 acres. And it is that lease deed and the area of land covered under that lease deed with which I am concerned with. I am not concerned, my lord, with what happens in and around that 10.19 acres. Problem started, my lord, in 2013, January 2013, when a letter was sent by the respondent. That letter, my lord, is important. That letter is at page 19 of the paper book, my lord.
Yes.
In this letter, my lord, the concession in para 1, admission rather, is important. I'll just quickly read para 1, my lord, the first paragraph. Yes. I, the undersigned, who is the elder Rangbakur of the Thank You So-and-so clan of so-and-so, CM ship so-and-so, have the honor to state that our predecessors in interest as the owners and on behalf of the whole clan had leased out to your club a plot of land situated at so-and-so, measuring a total area of about 10.19 acres, as per the schedule given below. The schedule is there, my lord. Below the schedule, my lord. That number one, my lord, there is a express admission on their part also. There is no dispute that in 1923, 10.19 was given to us. That agreement of the parties is important because this agreement of the parties, where both parties are of the same opinion that yes, 10.19 was given at one point, that was ignored by the appellate court, my lord. That was ignored by the appellate court. I'll subsequently explain how. Second paragraph, my lord, that the portion of land on the south, as shown and indicated very clearly in the said schedule above, has never been utilized nor fenced properly, resulting in a massive encroachment. But since the neglected and unutilized portion of land still remain with our thank you so and so clan as the owners with the trees standing thereon, therefore we hereby have decided to take back into possession. I'll pause, my lord. So the intention to take back into possession presupposes or requires that I am in possession, they want to take back in possession. So the issue of possession, if the issue plays on Honorable Court's mind, is in my favor, in the sense that I am in possession as per their own letter only. I'll continue, my lord. To take back into possession the said portion shown above, which is outside of the schedule leased to your club and not utilized or cultivated by any such person. In this regard, we would like to make necessary arrangements with your club for amicable handing over by your club and taking over possession by a thank you letter for clan of the said plot within 2 months from the date of receipt of this letter representation. So, my lord, on the last occasion also, Lordship himself had observed that there is no clarity of what is the exact claim that they are raising. They are saying the portion of land on the south. Now, the south is there. There is no clarity in the sense what is the boundary of the claimed portion. My
yes, Mr. General.
Yes,
sorry to interrupt.
Yes, madam. Yes, madam.
I think the last time around,
Yes, madam.
this court had requested you to
Yes, madam.
produce the sketch map.
Yes, madam. So I had both of us had informed this honorable court that there is no map which is exhibited. There is no evidence.
No, yes.
Nevertheless,
Exhibited, not on record.
yes, madam. Nevertheless, my lord, on the first day, I had
That would be, see, that would be issue of facts.
very well.
Because if there's an error of facts, this court can take up them.
Right. My lord, on the first day itself, I had submitted a compilation of relevant documents, which should be there before my lord. There is a map in that compilation, my lord. Page 52. In fact, it starts from page 50.
52 is not
compilation, my lord, not paper book. It's a yes, madam. Yes, 50. My lord. This is something prepared by the additional director of surveys, addressed to the assistant to deputy commissioner the suit court. A survey was carried out, my lord. A survey was carried out. Survey neither helps me nor helps the other side. If lordship sees that page 50, there is a table.
Yes.
So it makes that table refers to 3 plots, plot 1, 2, 3, and the area of those plots are also set out. Now, plots 1, 2, and 3 are reflected in page 52, my lord. Page 52, there is a map. So, if lordship sees closely, the bottom portion of that map, on the left bottom portion, is plot number 1. Middle portion is plot number 2.
Yes.
And topmost portion is plot number 3. Now, why I said that this doesn't really help adjudication of the issue is because the contested land, so to speak, is actually on the ground, plot number 1. This is behind Marin's restaurant, that jungle area, my lord. Plot number 1 is that portion. And just above plot number 1 is a road, is a connecting kind of road.
Yes.
This is where the clubhouse stands, my lord. My lord would be aware. This is where the clubhouse stands. And plot number 2 is the golf course, extending to plot number 3. Now, the reason why no one is really banking on this map is because plot number 1, lordship will see page 50, corresponds to 5.03.
Yes.
And what they had claimed was 6 acres. What they said was in 1914, their stand is, in 1914, they took back 6 acres. And according to them, that portion behind Marin's restaurant is that 6 acres. But 6 acres, that portion is not 6 acres, that portion is 5 acres. 6 acres, if at all, is plot number 3, which is in the middle of the golf course. Plot number 3 from page 50, Lordship will see it's 6.8 acres, yeah, 6.849. So if there is any plot which could correspond to that 6 acres, so which they claim was taken back by them, that is plot number 3 in the middle of the golf course. That is not the claimed area.
But this plot number 2,
yes, my lord,
the area is 10.19.
Yes, my lord. Which is our,
what has been stated in the agreement.
Yes, but our claim is that our 10.19 extends into plot number 1 also. Our 10.19 under the 1923 document, our claim is that it covers both plot number 1 and plot number 2. So this map, as I was saying, doesn't really help anyone because it doesn't help respondent.
How can you say that? Because whatever the drawing that you can see,
yes, my lord,
it has been clearly indicated as to the extent of the area.
True, my lord.
Of plot 1, plot 2, plot 3.
No, what has happened is the survey department, from the road, using the interconnecting road as a sort of a boundary, they have measured out 10.19 towards the north,
yes,
and said that this is 10.19. Beyond that, there is one more golf course area that comes to about 6.849. Yes. Now, our claim is that the road is a recent addition. It may not have been there in 1914, 1923. Our claim is that 10.19 under 1923 document is it is present in both plot number 1 and plot number 2.
This small portion.
Yes, my lord. That bottom below left portion, plot number 1, is included in the 10.19 acres, and it extends into the golf course also, 10.19 acres. So that is the reason I had said that it doesn't really help anyone on this map, because it just confuses everyone's claim. Because their claim is 6 acres that behind Marin's area. 6 acres is not that portion. That is a 5 acre portion. 6 acres is somewhere right inside the golf course, which is not their claim. So Lordship had asked for a map. This is the available map, but it doesn't really answer any questions.
Please continue.
Yes, ma'am. So as I was saying, my lord, problem started in 2013 with the issuance of this letter. The intention behind this letter was to take back something which was in a possession. Very clearly, there is an admission on the side that it is currently in your possession, you are not using it, so we will take it back. This was January 2013. Subsequently, some more developments were there. There were advertisements in the papers, etc., offering to sell certain portions of that land, etc. So we filed a suit. Now, the prayer in the suit is a very limited prayer, my lord. Page 10.
Yes.
If Lordship sees the primary prayer, prayer number 1, declaration that the plaintiff Shillong Club Limited is a lawful lessee in respect of the suit property. Suit property, my lord, is that 10.19 acres. As I said, we are not concerned with anything else, and holds the suit property under a valid perpetual lease deed. Number 2, declaration that the defendant or any of his agents, etc., etc., or any person claiming under or through the defendant have no right to disturb the peaceful possession of the suit property or any portion thereof, a perpetual and permanent injunction. Number 4, interim orders, etc., etc., my lord. So, Lordship would have seen, I am only concerned with my lease deed of 1923. As is evident, there is no dispute that there was a 1923 lease deed giving me 10.19 acres. I only sought a declaration in respect of that lease deed. I humbly and respectfully point out that there should not have been a problem or a difficulty for the court to declare, to grant me that declaration, for the reason that the parties were ad idem. Even they agreed that in 1923 there is a lease deed. Against the suit, my lord, WS was filed. Against the suit, my lord, there was no counterclaim filed. And that fact is important because ultimately relief has been granted to them in the absence of a counterclaim. No counterclaim was filed. WS was filed. In para 14, that is at page 34 of the paper book, a new version of events was placed.
Yes.
So, Lordship, the first version is in that January 2013 letter, which says that we have given you 10.19. You are not using the southern portion. So we will take back the southern portion. How much they want to take back? No clarity. But this was their stand in January 2013, that 10.19 has been given to you. You are not using a certain portion. We will take back that certain portion. Now, para 14, a second version of events has come up. The second paragraph, my lord, of para 14. In reply, it is stated that the predecessor in interest of the defendant on 20th October 1914, date is important, my lord, leased 16.91 acres of the land to the predecessor in interest of the plaintiff's club. Thereafter, due to bona fide requirement and on mutual understanding, 6 acres of the land situated to the south of the leased land was taken back by the predecessor in interest of the defendant, and a fresh lease deed dated 20th March 1923 was executed only for an area of 10.91 acres as in Annexure 1 of the plaint. Few days after execution of the fresh lease, it was discovered that the boundaries in the said fresh lease to the south remained unaltered, like the previous one in 1914. The then predecessor of the defendant raised this issue before the then members of the erstwhile Shillong Sports Club for causing necessary corrections to the deed. However, the then members of the plaintiffs' club assured that they too are men of words who keep their words as well, and that they would never question the landlord's title nor encroach into the predecessor's land beyond the allotted 10.91 acres on the mere minor technical defect in the document, and the predecessors of the defendant accepted that assurance. I'll pause my mind. So this version states, this version, while accepting that there was a document in 1923 giving us 10.19 acres, this version now states that actually, according to them, in 1914, there was a previous lease deed. In that previous lease deed, 16.91 acres was given to us, as per their version. Number one. Number two, according to them again, from that 16.91, 6 acres at that time itself was taken back by the respondent. After taking back of 6 acres, a fresh lease deed of 1923 was entered into. This is their version. Now, before addressing the merits or absence of merits of that version, very quickly, my lord, I seek your permission to point out the apparent and visible contradiction in their approaches. First, they say in January 2013 that we have given you 10.19 acres. You are not using a portion of it. We are going to take back that portion. When we objected and when we filed the suit, a different version came on record that no, 6 acres was given back to us before 1923 itself. And 6 acres, according to them now, is in their possession. The contradiction is apparent, my lord. I don't need to spend too much time on it. On the one hand, in January, they say that it's in your possession, we want to take it back. Now, in the WS file, few months later, they say that no, since before 1923, that 6 acres was always in our possession, my lord. That is the first aspect which needs to be highlighted in the WS.
It may be.
Yes.
I have not gone through the papers.
Yes.
It may be assumed.
Yes.
That out of the 16.91 acres, which was given to you on lease by that 1914 lease, 10.6 acres was taken back. But actually, it was not taken back.
Okay.
It may be so. That could be the picture that was painted. It was not taken back. All along, you've been in possession of that 6.91 acres.
Yes.
And eventually, now they've realized that that is the unused portion. You want to take it back.
Possibly, my lord. Possibly.
Irrespective of the fact that another lease of 1923 was
1923 was. Possibly, my lord. This may have happened. I mean, I cannot agree or disagree with that. It's a possibility, but
a presumption.
Presumption, my lord. But obviously, we'll have to be guided by the evidence. The evidence on record, acknowledged in the lower court's judgment, the suit court's judgment, is that there is no question of us having returned 6 acres to them in 1914.
Exactly.
So the defense or the case that they had projected, respondents had projected, lower court did not agree with that case. Their case was in 1914, we gave you 16.19 acres. Subsequently, we took back 6 acres. Lower court, the suit court, in its judgment, in the first judgment, is very categorical in observing that there is no question, this is the exact language used, there is no question of the plaintiff club returning 6 acres back to them at any point in time. I'll come to that also. I'll highlight that. This second aspect, same page, my lord, page 34, last paragraph. I'll just quickly read, my lord. Since 1923, the said portion of 6 acres remained in the absolute possession and occupation of the defendant and his clan, where he had also leased certain portions in and around the said land to different tenants by issuing pattas to them without any objection from the then members of the plaintiff's club, as assured by their predecessors. Again, the contradiction is apparent. Now they say in the WS that this 6 acres has always been in their absolute possession. Then where was the question of asking for possession in January 2013? January 2013, very clear demand raised, illegal, untenable demand, but nevertheless a demand was raised that give us the possession. Within 2 months, please arrange to give us back the possession. In the WS file, few months later, they say, since 1923, it's always been in their possession. This is the second important aspect. The third aspect, my lord, is in the next page, page 35, para 17. Para 17, my lord, this is where they try and explain away that January 2013 letter, because that letter, even they realize, causes a problem for their case. So what do they say? That the plaintiff was found, para 17, my lord, that the plaintiff was found to have surreptitiously constructed cowshed and other sheds housing the club's chokidar and others to the south of the leased land and on the north of the defendant's landlord's land. However, the defendant being a layman and an old-aged person with memories failing him, he was in no position to properly draft the wordings of the said letter dated 18th January 2013. However, the bona fide mistake and innocence of the defendant will not confer upon the plaintiff's club to take advantage of the same like any other opportunist before the court of law. This is in reply to para 10 of the plaint. So the explanation proffered by the defendant, the respondents, in respect of that January 2013 letter is, I am an old man. I did not, with memories failing, I was not in a position to properly draft that letter. Lordship, that cannot be an explanation, my lord. That cannot be an explanation because the same person who had issued that letter in January 2013 has signed the WS also. So for the purposes of the WS, if you are of sound mind and body and with all your faculties intact, you remember things that happened in 2014 also, apparently. You would have been in a position to draft a letter a few months prior to this WS also. So to say that I am an old man, I did not know what I was saying, it's neither here nor there. It cannot hold, my lord. That is as far as the WS is concerned. And once again, to reiterate, my lord, no counterclaim was raised. Evidence, my lord, was recorded. I produced one witness. Respondents also produced one witness. The evidence is more or less a continuation or a reflection of the respective pleadings. If lordship chooses to look at the evidence very quickly, my lord, that is at page, it starts from page 55, my lord, 55. This is the evidence, the chief examination of my witness. Now, the 1914 lease deed, which they have brought up in the WS, was addressed at para 10 of this affidavit, my lord.
Yes.
I'll quickly go through para 10, my lord. That in respect of the lease deed dated 20th October 1914, produced by the defendant, the humble plaintiff points out that the said lease deed purports to grant on lease an area of 16.19 acres for a term of 10 years from so-and-so to so-and-so. Most importantly, the said lease has been granted to Secretary Shillong Sports Club. It is humbly submitted that it is not known as to which entity is this Shillong Sports Club, since the plaintiff Shillong Club was incorporated, registered as a limited company under the Companies Act, should be 1913, only on so-and-so date. Therefore, the lease deed dated 20th October 1914 clearly does not relate to the plaintiff club. Para 11, my lord. That in respect of the lease deed dated 20th March 1923, it is humbly pointed out that it grants a perpetual lease to the plaintiff club over an area of 10.19 acres with effect from 1/4/22. This lease deed clearly shows the name of the lessor as Shillong Club, and it is this lease which is the relevant one for the purposes of the present suit. Further, page 2 of the said lease deed clearly refers to a previous lease which was to be in effect till 31st March 1922. This again brings out that the earlier lease deed dated 20th October 1914 could not have related to the plaintiff club, since this said lease deed dated 20th October 1914 was to be in effect till 31st March 1924 and not 31st March 1922, as is mentioned in the subsequent lease deed dated 20th March 1923. The response was simple, my lord. Firstly, that the 1914 lease deed, which they were relying on, was in favor of someone called Secretary Shillong Sports Club. It is not in favor of Shillong Club. Shillong Club Limited is an incorporated company.
It was not in existence at that point. Right?
It was incorporated in 1923 itself. So that's a different entity, number one. And number two, the recitals and the contents of the respective leases, the 1923 lease makes a reference to an earlier lease deed. That earlier lease deed, if examined, mentioned in 1923 lease deed, was not the 1914 lease deed which they are backing. It was some other lease deed which was cancelled subsequently. So because of these facts, our stand was very simple. Our stand is, you are also saying that you gave us 10.19 in 1923. There is no dispute as such, as far as that is concerned. We are only concerned with that 10.19 acres from the 1923 document. What 1914, etc., you're coming up with, we are not concerned with. We are not connected with that document. It's connected to some other entity, my lord. Page 59, next page. If lordship looks at the list of exhibits, papermark.
Yes.
Papermark 1, my lord, is that 1923 lease deed.
Yes.
Now, the original could not be located. So therefore, a papermark was produced. But the absence of the original should not have been any sort of impediment, for the reason that there was no dispute between the parties in respect of the 1923 document. So if parties are not in dispute, evidence is not required. Section 58, I think, of the old Evidence Act. Something not in dispute is not required to be proved, my lord. In any event, we have produced that document, papermark, as a papermark. The fact that we produced a papermark seemed to weigh very heavily on the first appellate court. How and why, I'll explain that. But lordship may kindly keep in lordship's mind that 1923 document was produced as a papermark, not as an original exhibit, my lord. Subsequently, my lord, the defendant also produced himself. The respondent also came as a witness, my lord. Page 94, my lord.
Yes.
Just from the chief examination, my lord, just one aspect I'll highlight. That is at para 3. para 3, my lord, at same page 94, my lord.
Page?
94, 94 of the paper book, my lord.
Yes.
First line itself, para 3. Thereafter, as admitted by both the plaintiff and the defendant in their pleadings, that before the expiry of 10 years, another lease deed dated 20th March 1923 was executed perpetually by the predecessor in interest of the defendant in favor of the predecessor in interest of the plaintiff for an area of 10.19 acres, and the remaining area of so-and-so, more or less situated to the south of the 10.19 acres, to reverted back to us. Now, what is important is, again, the admission by the respondent that, yes, in 1923, we entered into an agreement with you. We entered into an agreement with you. The reason why I'm repeatedly highlighting the fact that parties were not in dispute in respect of this 1923 document is for the reason that this first appellate court in the impugned judgment has declared that agreement itself as invalid. It was nobody's case. It was nobody's case that there was a problem with the 1923 document. It was everybody's case that yes, it was validly entered into. Subsequently, the other contentions about 6.72 acres, etc., that was addressed by the trial court itself in its judgment. So after producing of the evidence, my lord, the first court, the suit court, passed its judgment in 2015. That is at page 112. Page 112, my lord, is the first judgment. Now, this was in 2015, 23rd December 2015. Page 115, my lord. This is where the issues have been listed out. The issues that the suit court was dealing with. There are 6 issues, my lord. Page 115.
Yes.
I'll quickly go through the issues, my lord. Number 1, whether the parties entered into a registered lease deed dated 20th March 1923. Number 2, whether the said lease deed dated 20th March 1923 was to be a lease in perpetuity. Number 3, whether the defendant, vide lease deed dated 20th October 1914, leased out 16.91 acres of land to the plaintiff's club, and thereafter, by the lease deed dated 20th March 1923, reduced the area and leased out only 10.91 acres of land to the plaintiff's club. If so, whether the 6 acres of land situated to the south of the golf club, no longer leased to the plaintiff's club, stood reverted back to the defendant and his clan since 1923. Important issue, my lord. This is the crux of the matter. Number 4, whether the defendant issued letter dated 18th January 2000, should be 13, I think, expressing an intention to take back into possession the southern portion of the suit property. Number 5, whether the plaintiff's club raised any objection when the defendant leased out portion of the 6 acres of land to the Dorbar Shnong Golf Link Pinthomukra to Srimati so-and-so, Srimati so-and-so, Srimati Victoria Shobha, Srimati Margarita Khamunoid, where they have constructed and taken possession of the property. Number 6, whether the parties are entitled to any reliefs. So 6 issues framed, my lord. The first 2 issues should not and did not present any problem. The first issue was whether there was an agreement in 1923, a lease deed, whether it was to be a lease deed for perpetuity. Findings are at page 116. Issue number 1 and 2, the second paragraph, my lord, on 116. Both the parties have admitted to the fact that there was a lease deed dated 20th March 1923 between the parties, and according to section 58 of the Evidence Act, facts admitted need not be proved. Issues number 1 and 2 is decided that there was a lease deed dated 20th March 1923 and the lease deed was in perpetuity. Now I'll just pause, my lord. Now, Lordship may kindly recall what was my prayer. My prayer was concerning that 1923 document. My prayer was for a declaration that I have a lease deed in my favor, and consequently the respondent, defendant, has no right to disturb me in respect of that leased property. That was all. So the finding on issues 1 and 2, where court agrees that yes, there was a validly executed lease deed of 1923, should have decided the issue, my lord. Should have decided the entire suit in my favor. But nevertheless, the court went on to discuss the other issues also. Issue number 3. Issue number 3 was crucial because it pertains to their defense, my lord. Issue number 3 was whether in 1914 there was any lease deed between the parties, and whether 6 acres was returned back by us to them at any point in time, my lord. I'll read para 10, my lord. PW Shri so-and-so on his deposition on affidavit stated that the lease deed dated 20th October 1914, which is Exhibit A, is not related to the plaintiff's club in any manner, and he has reiterated in his cross-examination that the Shillong Club was incorporated as a limited company and registered under the Companies Act only on so-and-so date. This court also perused the Exhibit A, the lease deed dated 20th October 1914, and found that this lease deed was between the predecessor in interest of the defendant and the secretary to the Shillong Sports Club and not the Shillong Club. Clear finding of fact, my lord. Full stop. This court has also perused Annexure 1 and also perused Papermark A, which is the lease deed between the predecessor in interest of the defendant and the plaintiff club for an area of 10.19 acres of land. After perusing both the lease deed dated 20th October 1914, which is Exhibit A, and lease deed dated 20th October 1914, should be the 1923 document, which is Annexure 1 and Papermark A, this court found that the lease deed dated 20th October 1914 is not between the plaintiff club and the defendant, but the lease deed dated 20th March 1923 is the lease deed between the plaintiff club and the defendant for an area of 10.19 acres. So there is no question of the 6 acres of land situated at the south of the golf club being reverted back to the defendant since 1923. So the finding of fact of the lower court could not be clearer, my lord. First finding was that the 1914 document pertained to some other entity, not to me. Second clear, unambiguous finding was there is no question of the 6 acres of land situated to the south of the golf club being reverted back to the defendant since 1923. So the entire case or the defense of the defendant respondent was not agreed with. Their case was 1914 there was some other lease deed. Suit court says no, that was with some other person. Second defense was that 6 acres was given back by us to them at some point in time. Unequivocal clear finding by suit court that no question of the 6 acres of land situated to the south of the golf club being reverted back to the defendant since 1923. Again, I submit humbly, my lord, and respectfully, matter should have ended there, my lord. The finding on the issue number 1 and 2 was more than enough, that yes, there is a lease deed in my favor, validly entered into, etc. Finding on issue number 3, where their defense was not agreed with, was struck away, was done away with, that also should have been more than enough. But suit court went on, my lord. Now issue number 4 was discussed. Now issue number 4 is whether the defendant issued that January 2013 letter. Issue is the finding is para 11. PW Shri Parambi Singh on his deposition in affidavit has stated that on 18 January 2013, the defendant had issued letter in his capacity as Rangbakur of the Thank You Lagpur clan to take back the southern portion of the suit property as it was not utilized. This court has perused Annexure 3 and found that the defendant has issued letter dated 18th January 2013 expressing to take back into possession the southern portion of the suit property. Suit property, my lord, is that 10.19 acres. This court also perused Exhibit 4 and found that there was a communication by the plaintiff club to the defendant that the plaintiff club is concerned only with the 10.19 acres of land covered under the lease deed dated 20th March 1923, and the club does not have any claim to the 16.19 acres covered under the lease deed dated 20th October 1914. There is no finding. She discusses the evidence about the letter, but there is no finding whether in fact the letter was issued. Respectfully, my lord, I don't think there can be any dispute that yes, in fact, it was issued. Correctly, incorrectly, the writer of the letter knew or did not know what he was writing. Those are different aspects of the matter. But the fact that the letter was in fact issued in January 2013, there cannot be any dispute, my lord. Issue number 5 is where the court took a very surprising turn, my lord. Now, having agreed that yes, I did have a lease deed of 1923 covering 10.19 acres, a lease deed in perpetuity, and there is no question that I've given back 6 acres in 1923 or any point in time. There is no question that I've entered into any 1914 lease deed. After having concluded all that, the court decides issue number 5 in a rather surprising manner, my lord. Now, issue number 5, if Lordship recalls from page 115,
Yes.
is whether plaintiff club raised any objection when the defendant leased out portion of the 6 acres of land. The Dorbar Shnong Golfling so and so. Now, firstly, the suit court has said, I have not given back 6 acres to anyone at any point. Then the issue framed was whether I raised any objection when they apparently issued certain pattas in respect of some land lying somewhere around that area. Now, the pattas in question, just for Lordship's information, are also there on record, starting from page 99, my lord. 99A is a typed copy.
Just a moment, Mr.
Yes, ma'am.
Coming back to your
Yes.
map.
Yes, ma'am.
Now, as far as plot number 2 is concerned,
Yes, ma'am.
see, this contains 10.19 acres. Now, apparently the area of dispute would be the southern part, touches plot number 3.
Yes, ma'am. Plot number 1, southern part.
Oh, sorry. Southern part is plot number 1.
Yes, ma'am.
Plot number 1 belongs to the defendant.
No, it doesn't, my lord. I'll just again explain. Even though map is not part of the evidence, but just for clarity, my lord, what has happened when preparing this map is that the survey department has taken that connecting road as a starting point. And from that starting point, the connecting road, the survey department has mapped out 10.19 acres and said, this is your 10.19 acres, which you claim. Beyond that, more golf courses there that they classify as plot number 3, that is for roughly 6 acres. Now, the starting point, as I said, they've taken it as the road. Below the starting point also, whatever land is there, that jungle area behind Merins, they've measured that part. That comes to about 5 odd acres, my lord. Now, my point is simple, my lord. My point is, on what basis is the starting point taken as the road? I had taken 10.19 acres. Now, to take the starting point as the road and then measure out 10.19 acres is I would say an exercise without any basis, because why take this road as the starting point? My case is that my 10.19 acres is covered under both plots, and that plot number 1 has always been in my possession.
So right from the boundary of plot number 1 to plot number 2
is my 10.19 acres. 10.19 acres covered under 1923 document. Where 10.19 acres ends is the starting point of land covered under some other lease deed, because I have about 7 lease deeds for the entire golf course.
Plot number 3.
Yes. So to take an arbitrary point as a starting point and then to calculate, measure out 10.19 saying this is your land and this is not your land, that is absurd.
So plot number 1 is the disputed area.
Is the area they are trying to dispute. I am very clear, my lord. Their documents are also saying that I am in possession. I have always been in possession. Till today I am in possession.
Okay. So you would say that your boundary starts from this
From the road.
interstate bus stand,
Yes.
Pulo Bazaar,
So
Pulo
if
market.
yes, my lord. So if there has to be any calculation or measurement of 10.19 acres, it has to start from there. 10.19, wherever it ends, it ends. From 10.19, some other lease deed with some other entity, some other clan would be covering that portion. So this, I would say, is a is an exercise in futility, because it presupposes or starts its calculations from a random arbitrary point, my lord. Just to sum up, my lord, my 10.19 is over plot 1 and 2.
1 and 2.
Yes.
And now, as far as issue number 5 is concerned,
Yes.
where these
Yes.
land was leased out
Yes.
to
Yes.
somebody else.
So
this would be within this plot number 1.
So what has happened? This plot number 1 is till today vacant. There is no, because the allegation in the WS was that at some point they started giving pattas to various people, these other people, and those other people have set up, have constructed houses, etc. But till today, plot number 1 is vacant. So there's no question of them having given patta to anyone in plot number 1. What they have done is they have given pattas towards the northeastern side of that road. From that road, that connecting road,
Yes.
they have given pattas on the northeastern side to some 4-5 individuals.
Where the water tank and the transformer is.
Yes, my lord. Water tank, my lord. That Maupun road, my lord. Maupun is there mentioned.
Oh, Maupun, yes.
Yes, that road. They have given some pattas to some entities, some persons. Those pattas, just to inform, my lord, and this is on record, is under challenge. They're subject matter of pending suits, my lord. So to say that from the disputed area or the suit property, I gave pattas at some point to, they gave pattas at some point to somebody, is neither here nor there, my lord. This area, your disputed, your claimed area, is still today vacant. It's a jungle area. There's no dispute about that. It's vacant. Whose possession? They say they're in possession. I say I'm in possession. Their documents say I'm in possession, etc. That's another aspect. So even if you have given pattas, it is not in respect of the disputed area or the non-disputed area also. You've given pattas to the north, and those pattas are also under challenge. They're the subject matter of pending suits, my lord.
So the patta and the construction,
yes,
is in the middle of this plot number 2.
No, it's on the other side of the road. It's not on the golf course.
Other side.
Yes.
So okay. As far as you're concerned, I mean, this has got nothing to do with you.
Yes, those constructions of whatever nature, they are not intruding on the golf course.
Okay.
So till today, firstly, I was not bothered by that. Secondly, behind my back, using some mechanism, you issue some pattas to someone randomly. The fact that these pattas were issued came to our notice only after filing of the WS in sometime in September of 2013, I think. We immediately filed title suits. Those title suits are pending till date. So those pattas, such as they are.
So you would say that as far as those pattas are concerned,
yes,
your contention is they have intruded into your, encroached into your land.
No, my lord. No, my lord. It neither has it encroached into the plot number 2 as per the map,
exactly, that's what
into my golf course, or into that dispute, that vacant area, my lord. So
So what has that got to do? Why have you filed a suit?
Because of the confusion that is being created, my lord. They are saying that they have issued pattas. So we got concerned. When did you issue? To whom did you issue? We filed suits for cancellation of those pattas.
Let's put it this way. Logically speaking,
yes.
If this Maupun area is outside plot number 2,
yes, ma'am,
outside the boundary of plot number 2,
yes, ma'am,
whatever they do is not your concern.
Should not be, my lord. That I will request Honourable Court to allow the suit court, which is handling these matters, to decide. Lordship, I get the point that Lordship is making, that apparently those 4-5 plots, pattas, lie outside my leased out property. If that be the case, the suit court will dismiss my. I will not.
Why would there be a determination of an issue here?
Lordship, that is my grievance. That is my grievance with the suit court's approach. Suit court framed an issue regarding those pattas. The issues may have been framed. Issue may have been framed. You may have decided, but my entire suit was dismissed on the finding on this unrelated issue. If Lordship allows me to read out the finding on issue number 5.
Yes.
Now, issue number 5 is at page 117, my lord. The finding.
Yes.
I'll skip the first part, para 13, my lord. 1-3.
Okay.
This court has perused Exhibit B, C, D, E, F, 1, 2, 3, Annexure 3A, Annexure 5, and Annexure 7, and found that the plaintiff club did not make any objection when the defendant allotted the land to the Dorbar Shnong, Golfling, Srimati so-and-so, 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 but only in the year 2013, they have started making objections in general. This is after filing of the WS. In fact, the defendant had allotted the land in the year 1991 to the Dorbar Shnong of so-and-so, and the plaintiff's club has never raised any objection to this. And according to section 115 of the Evidence Act, the plaintiffs are barred by estoppel. I'll pause, my lord. Now, again, with whatever respect I can command, my lord, this has no relation to the subject matter of the suit. This finding is based on non-existent material, my lord, and to pick up some other unrelated issue and to decide my suit on this, because what has happened, issue number 6 was whether I am entitled to any relief. Finding is, under the present circumstances of the case and on the basis of the decisions arrived at the previous issues, it is redundant to discuss further on the present issue whether I should be given any relief. Court doesn't want to discuss only. The plaintiff is not entitled to reliefs under the present circumstances of the case. Now, I hesitate to use such words for a judicial pronouncement, but the absurdity in this judgment. Lordship, the absurdity in this judgment is self-apparent for the reason that first you say that yes, I have a lease deed of 1923. You agree it's a perpetual lease deed. You also acknowledge the parties are not in dispute. What is my prayer in the suit? Only confined and connected to that 1923. Then you say, the suit court says that there's no question that I've ever given back any portion to anyone. 6 acres to the defendant in 1923. The suit court says 1914 document, lease deed, is not my document. I'm not a party in that document. After having decided so many issues in my favor, this issue, which has no relevance or nexus with the suit, where court comes to a conclusion that yes, pattas were issued by defendant to some other people. Yes, apparently I never objected. I had no idea about these pattas. In any event, because pattas were issued to some unconnected land, because I never raised objections for some unconnected land, my suit is dismissed. That cannot be. My suit was confined to 1923 document. You have agreed that I have a valid 1923 document and there is no dispute between the parties on that document. Having agreed all that, to dismiss my suit, in my humble submission, was a travesty, my lord. So my suit was dismissed. Against the suit, on the same day itself, I filed a appeal, my lord. Appeal with the additional Deputy Commissioner, Judicial. Appeal, my lord, was filed in 2015 itself. Appeal was pending for a very long time. Finally, last year, in October, my lord, the appeal court passed its judgment in the matter. Judgment, my lord, starts from page 149. Now, 149, my lord, what the first appeal court has done is, on the first page itself, under case of the plaintiff in the suit, it has summarized my suit. It has the appeal court has faithfully reproduced my entire plate, my lord. So I will not waste honorable court's time on this. That reproduction of my plaint, my lord, goes up till page 156, my lord. Page 156, first appeal court then, my lord, faithfully reproduces the written statement. Then that reproduction, my lord, goes up until page 159. Page 159, my lord, appeal court lists out the issues which were framed, my lord. Page 160, it makes a reference at para 42 to the evidence adduced by the parties. Just a reference, how many witnesses, etc. No discussion of the evidence, my lord. Para 43, judgment passed by the learned trial court, makes a one paragraph reference to the impugned judgment that was before the first appeal court. Then thereafter, grounds of appeal. Whatever grounds of appeal I had taken in my memo of appeal, my lord, have been faithfully reproduced, my lord. 163 is where finally the appeal court attempts to apply its own mind on the issue. Points for determination, para 45. The question that is required to be answered is whether the impugned judgment dated 23/12/2015 is sustainable in facts and law of the case. To understand the rival contentions, let us discuss the evidence on record. I'll just stop here, my lord. Para 45, a certain point for determination has been formulated by the first appeal court. What is the point? The question that is required to be answered is whether the impugned judgment dated so-and-so is sustainable in facts and law of the case. Lordship, much more was required by the first appellate court. Being a first appellate court, there was a bounden duty on the first appellate court to formulate points for determination, which points for determination would have to be answered with reference to the evidence recorded by the lower court. What is the point that is formulated? A very general, broad, I would say a meaningless point, that whether the impugned judgment is sustainable. That is the only point. As I said, much more is required. In this connection, with Lordship's permission, I will draw Lordship's attention to the law on this point. In this compilation, my lord, page 15 of the compilation, 1-5. Page 15 is the 2021 Supreme Court judgment, where the Honorable Supreme Court has listed out the duties of an appellate court, my lord.
Yes.
Para 7 to 11, my lord. I've just extracted the relevant paras. Para 7 to 11.
Yes.
I'll read, my lord. Para 7. In the present case, the original plaintiff instituted a suit for specific performance of the contract. On appreciation of evidence, the learned trial court held the issue of readiness in favor of the plaintiff. However, refused to pass the decree for specific performance of the contract on the ground that the plaintiff was not willing to purchase the property with tenants. Therefore, the issue with respect to willingness was held against the plaintiff. In an appeal filed before the High Court under Section 96, read with Order 41 by the impugned judgment and order, the High Court has allowed the said appeal and has quashed and set aside the decree passed by the learned trial court dismissing the suit, and consequently has decreed the suit for specific performance. Having gone through the impugned judgment and order passed by the High Court, it can be seen that there is a total non-compliance of Order 41, Rule 31 CPC. While disposing of the appeal, the High Court has not raised the points for determination as required under Order 41, Rule 31 CPC. It also appears that the High Court, being the first appellate court, has not discussed the entire matter and the issues in detail, the issues which were framed by the lower court, my lord, issues in detail, and as such it does not reveal that the High Court has reappreciated the evidence while disposing of the first appeal. It also appears that the High Court has disposed of the appeal preferred under Order 41, read with Section 96, in a most casual and perfunctory manner. Apart from the fact that the High Court has not framed the points for determination as required under Order 41, Rule 31 CPC, it appears that even the High Court has not exercised the powers vested in it as a first appellate court. As observed above, the High Court has neither reappreciated the entire evidence on record, nor has given any specific findings on the issues which were even raised before the learned trial court. So, Lordship, it goes on, para 8, 9, 10, 11 is there, but this para 7 more or less sums up the duties of appellate court. First, appellate court, my lord, has to frame issues for points for determination. This point framed by the first appellate court in our matter, whether the lower court's judgment is sustainable, it's hardly a point, my lord. It's hardly a point. So the first duty was not complied with. There was a failure on the part of the first appellate court to comply with Order 41, Rule 31. If Lordship, at Lordship's leisure, looks at Order 41, Rule 31, the duty to formulate questions is there. No question has been formulated. And whatever questions, semblance of a question was formulated is hardly any question at all.
That's the bill.
Yes. Saved by the bell again. Who will receive you?
So, what do we do?
Continue.
After Lordship rise up division bench is subject to Lordship convenient. My friend is almost, I think, covering his point.
No, it takes some time because
or tomorrow, my lord.
Because we don't know how long matter takes.
My lord. Lordship, if I can pray for Thursday, my lord. Thursday or Friday, my lord.
Friday, I think.
Friday, if that is convenient.
Sunday. Sunday. Friday.
John connected.
We'll take it up on Friday.
Friday.
Heard Mr. S. General, Learned Counsel for the appellant, who is yet to conclude his argument. The same will continue on next date fix. As agreed to by the parties, this is matter on 29. A further hearing.
Yes, published.